In today's video, I want to take a look at buying a new house in Ireland. Buying a new house is significantly different from buying a second-hand house. The differences are primarily: one, at contract stage, there will usually only be a site with an agreement to build a house on it. Two, the vendor will normally be a limited company or building company, not a private individual who you might encounter, for example, a family selling a second-hand house. Three, the house will be built in accordance with the building agreement and to certain specifications and agreed standards. That's the plan anyway. Four, there will be a large time gap between paying the booking deposit, signing the contract and final handover of the built house, because obviously the house has to be built, and it's with signing the contracts, paying the deposits and so on that the builder will be relying on to finance ongoing construction of a development. Buying a new house then involves two contracts. One, the building agreement, in which you, the purchaser, are considered to be the employer and the builder will be considered to be the contractor. And two, a contract for the transfer of the site on which the property is built. So you'll be getting the transfer of part of a folio on which your property is going to be built. That will be transferred to you. So that's the second contract involved. The building agreement is the most important document probably in buying a new house. It sets out the obligations of both parties. The standard building agreement contains a covenant by the builder to build the property to a high standard and in accordance with the plans and specifications. However, the purchaser should engage the services of an architect or a building surveyor or an engineer to assist with ensuring that the property is built according to the plans and specifications. Quite clearly, it's easy to have plans and specifications, but they should be adhered to, and that's where an architect or a building surveyor or an engineer might come in very useful for you to ensure that that happens. The building agreement will then just contain a payment clause, and it will provide for 10% of the purchase price of the property to be paid on signing the contract. It will also cover possession of the site clear and fit for human habitation. It'll cover the materials to be used. It'll cover planning permissions and building regulations, interest penalties being imposed for not closing on time. It'll cover the insolvency of the contractor situation, what happens then. It will cover and contain a price variation clause. It will cover insurance, liability for defects, limitations on the builder's liability, the common law rights of the purchaser to sue for negligence and breach of contract, and it'll also cover the estate services. It will also have a completion date, and it will provide for arbitration in the event of a dispute. The contract for sale, on the other hand, as opposed to the building agreement, will be the standard law society contract, and it will provide for the transfer of the site on which the new house is built. The most important thing to note is that it deals with the legal title to the site and the physical location, boundaries and dimensions of the site, and it will have a plan attached to it, a little map which will show the particular site that you're getting, which will be carved out of the site plan, which will be carved out of the folio plan. The contract for sale will contain then the parties, the closing date, the purchase price, the particulars and tenure of the property. It'll be freehold if it's a house, and it'll be leasehold if it's an apartment. Any special conditions inserted by the builder's solicitor. The general conditions of the standard law society contract obviously will be incorporated. Other important documents then in relation to the purchase of a new house will include a booklet of title showing the vendor's title. It will include, or other important documents will include, replies to objections and requisitions on title. Objections and requisitions on title are standard queries, standard requisitions that a purchaser's solicitor will raise in any conveyance, any property deal, and this replies to objections and requisitions will foresee all of these queries, and it's a standard set of replies, standard set of requisitions rather. The replies obviously will be for that particular development. Other important documents will include a Section 72 declaration, which will deal with any burdens which affect registered land and which may not be registered. a declaration of identity from an architect or an engineer confirming that the site and all easements and services are within the boundaries of the vendor's folio or title is an important document as well. An indemnity in respect of roads and services. This provides that pending the taking in charge of the estate by the council, that the developer or builder will give an indemnity that's a guarantee to maintain them. There will also be a right to reach the public highway from the property. So you need obviously access to your property, legal access to and from your property. You may also get an indemnity in respect of footpaths, grass margins and curbs. In other words, again, who maintains these before the council, the local authority, takes the estate in charge. The deed of assurance in the site or a lease in the case of an apartment will be also provided as part of the final closing documents. The deed of assurance transfers the site to you, and the lease then is very important insofar as it will give the term of the lease and the various conditions for how the management, how the estate will be managed and so on, how the apartment development will be managed. You'll also have a family law declaration, which is absolutely standard in any conveyance of property in Ireland because of the Family Law or Family Home Protection Act of 1976. So if any structural defects, hopefully there won't, but if any structural defects do arise, then there are generally three avenues open to you. One will be a claim to the National House Building Guarantee Company pursuant to the Home Bond Guarantee Scheme or Premier Insurance Scheme. That's assuming that the house is being provided with a home bond guarantee or a Premier Insurance Guarantee, and that's assuming that the builder is registered with the National House Building Guarantee Company. You would hope that that would be the situation, and that is probably going to be a condition of your loan offer from any lender, that there is a home bond situation there. That's something that needs to be checked out. If there isn't any home bond or Premier Guarantee Scheme, then you have two other avenues open to you. One will be legal action against the builder based on the grounds of negligence, and the other will be legal action against the builder based on breach of contract. The difficulty with those two avenues, however, is that if the builder goes into liquidation or becomes insolvent, any legal action against that builder will be as useful as a chocolate teapot. So that's why having a home bond guarantee or a Premier Insurance Guarantee to deal with structural defects is highly recommended, and something, as I say, that the lender will be looking for. Buying new is different from buying second hand, there's no doubt about that, and you, I hope, have some better idea of what's involved in buying new now. My name is Terry Gorry, I'm a solicitor in Enfield. My contact details are on the screen. If you find this video useful, I would appreciate if you'd give it a thumbs up down below on YouTube, and thank you for all of your comments, shares and likes on my YouTube channel. You may be interested in subscribing to my channel, which deals with all aspects of Irish law and Irish business.